As a real estate agent, one of the biggest mistakes you can make when taking a listing is to not know the status of the title, particularly whether the person that you are speaking with about selling the home actually has the legal authority to sell it. My name is Sharon Smoot. I'm a realtor and a residential real estate closing attorney in the metro Atlanta area. And today I want to talk to you about transfer on death deeds. Now, the transfer on death deed is a relatively new thing in Georgia. Back in July of 2024, this law came into effect that actually recognizes transfer on death deeds in Georgia. So, how does a transfer on death deed work? What is a transfer on death deed? A transfer on death deed allows a homeowner to avoid probate. That's the first thing you need to know. This deed allows the homeowner to designate who the property should be transferred to upon the homeowner's death. How does it work? The homeowner signs this document and it's recorded in the real estate records of the county where the property is located. And in the document, which has to include the legal description of the property, the homeowner says, "This is who I want to get my home when I die." But here's the kicker: transfer of title does not happen automatically when the homeowner dies. There's a process that has to be followed. And this is where, as a real estate agent, you can get in trouble. So, you're at a listing appointment and the person that you're speaking to says, "This was my mom's house. She signed a transfer on death deed. Here's a copy of it." And you're like, "Okay, good, great. We can go ahead and move forward with listing this house and getting it sold." Let's pump the brakes. That is not how this is going to work, okay? If that's what you do, you're going to run into problems when the house goes under contract. You send it over to the closing attorney to order title, and they're like, "Oh, no, this deal can't happen." So if you're still with me, go ahead and type the word transfer in the comments, just so that I know that you're still watching. So let's go to the next step. I mentioned a little while ago that the transfer does not automatically happen when the person dies, when the homeowner dies. So what do you need to do? What does your client need to do? Well, when a homeowner utilizes the transfer on death deed, the person that they designate has 9 months from the date of their death to have an affidavit recorded in the real estate records of the county where the property is located. That affidavit, along with the death certificate, have to be recorded, and the affidavit has to set out that there was a transfer on death deed, dated whatever the date is, recorded in deed book, whatever, page, whatever, and that the homeowner, the grantor, died on such and such a date, and that affidavit gets recorded. That's how you effectuate the transfer. So if you're in a situation where you're speaking to someone who says that they've acquired title via a transfer on death deed, your first question needs to be, did you file the necessary affidavit within the required time period, within 9 months of the grantor or the homeowner's death? If they did not file that affidavit within that 9-month period, then the estate will have to be administered or probated. Okay? The will, assuming there's a will, the will would have to be probated. If there's no will, then the estate would have to be administered. And that's going to prolong the process. And until such time as one of those two things has happened and that person or someone else has received authority from the probate court to act as the executor if there's a will, or the administrator if there was no will, to oversee the disposition of the decedent, that's the dead person's estate, nothing can happen. That property cannot be sold. That listing agreement means nothing. It's void because the person who signed it doesn't have authority to act on behalf of the estate. So I just want to reiterate that if someone tells you that they have acquired title via a transfer on death deed, you need to make sure that they filed the necessary affidavit along with the death certificate within 9 months of the decedent, the grantor's death. If they did that, then you're good to go. If they didn't, you need to be referring them to someone who can help them get that will probated or get the estate administered if there was no will. If you have any questions about transfer on death deeds, put them in the comments and I'll be more than happy to answer them. And be sure to get my freebie. The link is in the comments. It is a probate listings checklist.